All right, good evening, Board of Adjustments. We'll go ahead and get started. The time is 5:34. Just as a reminder to our board members, when you are speaking, please make sure to unmute your microphone so you can be heard on the broadcast. The public that did not register in advance can watch the live broadcast on the city's YouTube channel. For live Spanish translation services, please dial 720-386-9023 and use code 104091 for Spanish translation services.
Okay, I'd like to call this regular meeting of the Board of Adjustment to order. Will staff please do roll call?
Board Member Liffel.
Present.
Board Member Poe.
Present.
Chair Hernandez.
Present.
And Council Member Douglas.
Here.
Chair, you have a quorum.
Great, thank you. All right, so we'll get started. Can I get a motion to approve the February 11th meeting minutes?
I'll make such a motion to approve the February 11 meeting minutes as presented.
May I second that?
Thank you. We do have a motion by the board, by Board Member Leffel, and a second by Board Member Douglas. Thank you. If we can please open the electronic voting.
Yeah, you don't get to vote.
Yeah, I wasn't here, so I abstained.
Did it get mine? Oh, there we go. Okay.
Sorry, we're going to open it back up again because I didn't get one of your all's votes. So if we could just, the folks of you all that were here could just revote real quick. Board Member Leffel, can you vote again?
Again?
Sorry, yeah, there you go. Perfect.
Great, looks like the motion passes. Thank you. Okay. I will now open the public hearing for this case and ask Planner Allison Olson to please announce this case.
Thank you, Chair. There we go. Fast Cash Pawn is requesting a use-by permit for a pawn shop in the C3 Regional Commercial Zone District for the approximately 0.6 acre property located at 6225 East 71st Place. Some background on the case, this is the renewal of a use-by permit to operate a pawn shop located at 6225 East 71st Place. Some background on the case, this is for a previously approved use-by permit that was approved in February of 2010 with the requirement to renew the permit in 15 years. The ownership and operations have not changed since its initial approval in 2010. Quick look at the vicinity map and zoning. This property is surrounded by C3 and C2 commercial properties to the north, east, and south, and then it is buffered by Highway 2 to the west. Quick look at some the aerial and site photos of the property as it exists today. This request was reviewed by the development review team and all necessary agencies such as engineering, economic development, and the South Adams County Fire Department, and there are no outstanding comments or concerns from any of these agencies. The Commerce City Police Department does not have any crime-related concerns with the continuation of this use and recommends this permit for approval with conditions. This is a quick look at the approval criteria for the use by permit. Staff has provided an analysis of each of these approval criterias, and if the board would like to discuss that any further, we're happy to. And some considerations for this case, the proposed use has existed on the site since 2010. Ownership and use have not changed since the initial use by permit was approved. The approval has been recommended by the Commerce City Police Department with conditions. This use is consistent with the Commerce City 2045 comprehensive plan. And the recommended conditions, one from the police department recommends that the applicant shall participate in the police department's stolen merchandise tracking program and that on-site vehicle sales are prohibited. Staff is available for any questions.
Great. Thank you for the presentation. Do we need to do anything official for attendance?
And mine won't unmute, or, yeah, won't mute. Joe Fry is in attendance.
Thank you. Okay. And are there any questions for the applicant by the board? Board Member Douglas?
Thank you so much. Are you able to meet the conditions that the police department would like to see in place? Yes? All right, very good. Thank you.
I guess we can't speak. It works. Okay. Can you just,
Yes.
All right, just want to make sure that when putting any extra burden on you that you aren't willing to
Okay.
take on. All right,
Okay.
thank you.
You're welcome.
Thank you. And board, are there any questions for staff? Yes, Board Member Fry?
Okay, sorry, different system. Just to clarify, so it is currently a pawn shop now and is staying a pawn shop, and we're just renewing because the application seated in 25.
Correct.
Okay, and you're still the owner, and it's, you own the pawn shop now and you'll continue?
I'm actually not the owner, I'm the district manager of the location,
Okay,
but it is owned by
the
the
same
same
owner?
company, yes.
So just okay.
Yes.
Thank you. I read that, and I'm like, I just want to clarify.
Could you say your name for the record?
Richard Dawson?
Right. Thank you, Richard.
Appreciate it.
Any other questions? Okay, great. All right. Do any members of the public wish to provide comments on this case?
And if the applicant would like to provide any,
Okay,
their case as well, they can
Okay.
provide comments as well. if you would.
yeah, sure.
I'd just like to say we're one of the bigger pawn shops in Colorado. I think we provide a lot of needs for the community for sure and come pretty close with the community members there for sure.
Great, thank you. Do we have anybody attending virtually tonight that would like to speak?
We did not have anyone registered beforehand, and no one has raised their hand.
Okay, great. Okay. All right, with no further questions and no responses needed for public testimony, at this time, I will now close the public hearing for this case. Is there any discussion from the board? Okay, it appears there's no discussion. Can I get a motion? Motion for approval?
Member Douglas, did you want to make, are you making the motion? I make a motion, is the motion up, can you pull it up on the screen? Yeah, I was just going to recommend. I want to make sure, thank you. I recommend approval with conditions, as noted by staff. Do I have to list them?
Do you want to read?
can you read the motion?
Oh, okay, so.
That'd be helpful.
sorry. The county
Yeah.
the county BOA, you just say, I make the motion as presented.
Okay.
So, all right. Approval with conditions. I move that the Board of Adjustment enter a finding that the requested use by permit for the property located at 6225 East 71st Place contained in case AU 25-1 meets the criteria of the Land Development Code and based upon such finding, approve the use of permit subject to the following conditions: participate in the police department's stolen merchandise tracking program. 2, on-site vehicles sales are prohibited in 3, just those 2.
Can we get a second?
May I second that, please?
Great, thank you. We have a motion by Board Member Fry and a second by Board Member Douglas. Is there any discussion from the board? Nope, all right. If we can please open the electronic voting. Looks like we have a vote. The motion does pass. Thank you, everybody. Oh,
Jean did not vote.
Jean did not
Did we
vote?
close that too quickly?
It doesn't got that screen right there right now, the voting screen.
All right, you're good to
Okay,
go.
there we go. We got,
Take the votes now.
Thank you.
We have all votes in now this time, and the motion does pass. Thank you.
Yay.
Is there any board business to discuss at this time outside of our study session? Who's interested on the board? There's no discussion. Okay, all right. Is there any attorney business to discuss at this time?
No, not at this time.
Great, thank you. Is there any staff business to discuss at this time?
No, just wanted to welcome your new member, Sean Poe.
Hi, Sean.
Welcome.
Very glad to be here, thank you.
All right. So the time is now 5:46 PM and the regular meeting is adjourned. The Board of Adjustment take a brief recess and reconvene for a study session on the Board of Adjustment rules and land use training.
And I want my audio and video off.
Yeah, that is.
Okay. Thanks, Andrew. Okay, have a good evening. Yeah. Okay, thanks for your patience. We've got our technology up and running, so we'll go ahead and get started with the study session. Tonight, we're going to be presenting to you on land use training. This is a general land use training on how land use in Commerce City works. And I'm going to be tag teaming with Elliot Schaefer, our city attorney, he's going to talk to you about quasi-judicial hearings and ex parte communication and how to kind of run your meetings. But I'm going to handle the first part on land use. So basically, in Commerce City and in other places, you start off with planning and community planning. So that's your comprehensive plan, and there's lots of outreach and communication that goes into getting your community and neighborhood plan developed. And then you move into the regulatory phase, which are your rules and regulations. And then developers come in and they work with you on design of infrastructure and development. And then finally, the last stage is once you get the horizontal infrastructure in, which is your roads and your utilities, then you can go vertical with your construction. And that's either residential or commercial or industrial buildings. So community planning, in this case, we're showing you images of the comprehensive plan, a station area master plan that was done for our light rail station, and the Parks, Rec, and Golf master plan. These kinds of planning documents establish an overall vision and goals for the community, and you want lots of public outreach to develop these sorts of plans. And these should be long-term plans that carry the community through for multiple years. So the development stages, after you get your planning documents in place, then you want to move into the regulatory phase, which is the creation and establishment of rules that govern development, and the establishment of zoning and other rules such as engineering standards and design regulations. Your neighborhood design and horizontal infrastructure development is establishing the layout and the system of land uses and open space, your roadway and your mobility systems, your infrastructure, your engineering design of roadways and utilities, and then in that phase, you're also constructing the horizontal infrastructure, doing your subdivision platting and civil construction plans. And then finally, your last phase is vertical development, which is design and site planning of individual lots, building design and architecture, and construction of the actual buildings. And that's the building permit phase. So this diagram just helps you understand the level of public participation that's needed. So at the early phases, when you're developing your community and neighborhood plans, that's when you want a high level of public participation. As you move through to development regulations, you still want to get public input, but not necessarily in the enforcement of those regulations, just in the development of the regulations. And then as you transition into neighborhood design and horizontal infrastructure and vertical development, it's more about informing the public about what's happening as opposed to trying to get their input, because those are administrative processes. So the basis of authority for the city of Commerce City and other communities in Colorado comes from the state enabling regulations, the Local Government and Land Use Control Enabling Act. And what we do in terms of zoning and regulations in Commerce City is an exercise of our police powers that are promoting the health, safety, and general welfare of the community. And all of those authorities are derived in the Constitution. So due process requirements, when you have the exercise of police powers, it's important that you have due process for your applicants and that government can't be arbitrary or capricious in its decisions. You have to have defined rules and procedures that are established in your codes. The municipal code establishes the rules and procedures for permitting and the use of private property within Commerce City. So we have different types of regulations. We have the Land Development Code, which is the zoning and the land use standards, subdivision regulations, development and design standards, and sign regulations. And then we have separate documents that are the engineering, design, and construction standards. And then finally, we have building codes. And building codes are often adopted as international codes, and so these are widely used around the world. So in terms of phases of development, you start off with annexation and zoning, which is bringing properties into the city, incorporating them into the city. Subdivision platting is when you do your horizontal infrastructure and you actually divide the property to be sold. Development plans show you the specific layout and configuration of what the site's going to look like. Grading permits allow you to move dirt and do earthwork on the site. And then finally, building permits allow you to do vertical development, which is above ground construction. So annexation. Annexation is the process when a property owner wants to be incorporated into Commerce City or into any community. And annexations are approved by City Council at a public hearing. This is just what an annexation plat map looks like. It shows you the boundary of the existing property that's in Commerce City and then the area that's to be annexed. Zoning. Zoning is approved at a public hearing, and that's recommended by Planning Commission and decided by City Council. The zoning determines what uses are allowed on the property and sets the bulk development standards, such as the setbacks, the lot size requirements, and building heights. Zoning is general in nature and does not determine what specific use will occupy a specific parcel. And zoning runs with the land. So your zoning stays there until it's modified by a subsequent zoning action in the future. This map just shows you how Commerce City is zoned and what our land uses within our PUDs are. So the core city, which is the south part of the city, is straight zoned, meaning either residential, commercial, or industrial zoning. On this map, yellow is residential, red is commercial, and industrial is purple. And our northern neighborhoods are mostly zoned PUD, but for purposes of this map, what we did was show you what the different land uses within those PUDs are so that you can see the residential, the commercial, and in the industrial areas in those PUDs. And speaking of PUD zoning, if you're not straight zoned, which is just residential, commercial, or industrial, then you're PUD zoned. And PUD takes the place of that straight zoning and applies land uses and standards to the property. PUD has to be approved at a public hearing, which is a recommendation by Planning Commission and a decision by City Council. And the intent of the PUD zoning is to support a unique development that wouldn't be feasible through straight zoning. So when someone comes in and talks to us about PUD zoning, we're asking them, what's unique about your development? Why can't you just do straight zoning? You know, and they need to have a compelling reason why their PUD is necessary. This is just an example of what a PUD document looks like. You can see that it's for a specific geographic area. It shows where the roadway access points are going to be, and it shows you what the different land uses of either residential, in this case, public school dedication or public park dedications. And the different intensities of residential development are shown through the gradients in the color. So subdivision plats. Subdivision plats actually divide the property into lots and tracts or right-of-way dedications, and that allows property to be able to be sold. It creates the legal boundaries, and it also creates easements on the property, which are just the use of that property, not the ownership. Subdivision plats can't be approved unless utilities are adequately serving the site. So when we go through a subdivision plat review internally at the staff level, we're looking to make sure that water and sewer and fire can all be accessed and provided service before we approve that plat. Plats are generally approved administratively, but we have a process in Commerce City that allows plats to be called up by City Council. This is what a subdivision plat looks like. You can see with the heavy boundary and the circles at change of direction where the perimeters of the lots and tracts are. And this is a survey type document that's done by a professional land surveyor. And then it gets recorded at the county, and the county derives their parcel layer off of these subdivision plat maps.
I had a question. A
Yes.
clarification question. So for the PUD and then the plat map, can you explain how those interact with each other?
Yes, so PUD is zoning. So that establishes what the land uses are. A subdivision plat map establishes whether it's a lot or a tract that can be sold or conveyed. So zoning is just a layer on top of the property that establishes what the land uses are. And a PUD is a planning document that shows you what the different zonings are in different areas of that property. So you might have what are called planning areas. Planning area A may be residential, planning area B may be commercial, planning area C might be mixed use. So those are different land uses that are identified. And the PUD is a governing zoning document. But subdivision plats are like if you have a residential subdivision with multiple lots, those have to be platted as a subdivision plat before individual homeowners can purchase their lot. So a subdivision plat is a lot conveyance or a property ownership conveyance document versus a zoning document.
So just for the PUD, just to clarify, once it's approved, if it's approved, after it's approved, all the properties are now straight, like R1, or are they separate from the zoning code?
So a PUD takes the place of the zoning.
Oh, okay. I wanted to make sure that I understood that out here, because
Yeah.
Colorado has some different rules, and so
Yes.
I wanted to clarify from historical training I have.
Some
like,
PUDs, in some communities, PUDs lay on top of the zoning as a layer. But here in Commerce City, PUD takes the place of the zoning.
Okay.
So you either have straight zones, R1, C1, I1, or you have PUD zoning. You don't have both. But in some communities, PUD lays on top of zoning. So conditional use permits. Conditional use permits
Heather,
are
would you mind if
similar-
I ask
Oh,
a
yeah.
question before we
Sure, I'm
proceed?
sorry. Of course.
So you previously said that PUDs have to be unique. Can you define unique?
Well, that's what we ask of PUDs in this time. I'm not sure that that was always the case in Commerce City. I think a lot of PUD documents were approved in the past.
Yes.
And perhaps didn't provide anything unique, but that is something that we ask of PUD developers today.
Going forward. Thank you
Yeah.
so much. I appreciate that answer.
Okay, so conditional use permits. Conditional use permits are uses that need additional review or scrutiny to make sure that any negative impacts are mitigated before the land use goes into place. A conditional use permit is required on certain types of uses in certain zone districts. And it only allows those specific land uses on the specific property. It doesn't alter the underlying zoning. So kind of like the use by permit that you saw tonight, a conditional use permit is required to have an extra layer of review. So those are actually heard by Planning Commission and City Council. And the types of land uses in Commerce City that require conditional use permits, for example, are like manufacturing, landfills, recycling centers, truck stops, the uses that could have additional impacts that need to be mitigated. This was just an example of a conditional use permit that went to council recently, and it was for truck parking on this lot. So one of the conditions was that they have fencing and landscaping around the perimeter to make sure that their visual impacts were mitigated. Development plans are specific plans that pertain to a particular property, and they show the site design, the layout and configuration of the property, including the parking, the landscaping, the lighting, what the building design is going to look like. PUDs, development plans in Commerce City can either be for straight zones or for PUDs. And once they're approved, the developer can move on to building permits. This is an example. This is a very busy plan, and it's one of probably 50 pages in this plan set, but it just shows you in the middle of this site, you can see where there's a parking structure, and then you can see building footprints around the perimeter and landscaping and driveways. So a development plan is very specific about exactly what's going to be built on the property. So the overall development process, again, in that regulatory phase, you're looking at annexation and zoning. In the neighborhood design and horizontal infrastructure development phase, you're looking at subdivision plating and infrastructure construction documents and engineering permits. And then finally, in vertical development, you're looking at development plans, conditional use permits, building permits, and site-specific civil construction plans. This diagram just shows you the process that staff and an applicant go through when reviewing different types of development applications. The application gets submitted and then gets distributed to internal and external agencies. It gets reviewed by the development review team, and all the comments from those outside agencies get consolidated and sent back to the applicant. The applicant makes revisions and goes back through the process. That can happen multiple times, sometimes 3 or more times, before a property or before a development application is ready to either go to public hearing or to get approved by staff. So I wanted to focus for a minute on Board of Adjustment applications. You all hear variances, height exceptions, use by permits, and administrative appeals. And there's different review criteria for each of those types of applications. So a variance is something that is specific to a bulk standard that applies on the property, for instance, a setback. And you have to find that the physical character of the property is either a unique situation or that other properties have privileges that this property is denied. That the hardship that's created needing the variance is not self-imposed, and that the variance will not be of substantial detriment to the adjacent properties. And then in addition to those criteria, you have to find that either the variance is the minimum needed for reasonable use of the land, or that the character of the district won't be changed by the granting of the variance. Height variances have specific review criteria in and amongst themselves. The structure and the criteria relate to whether the structure complies with all other standards not specifically waived by the city, whether the exception will have minimal impact on adjacent properties with regard to solar access, visual access, and right of privacy, The exception will not interfere with the city's ability to provide public services to the site, and that there's evidence to suggest the exception would interfere with or complicate emergency services or otherwise impair public safety. No evidence to support that. And then you have to find additionally that the exception provides a demonstrated benefit to the city, or that the architectural character and proposed building or structure will exceed the height standards or compatible with the existing development on surrounding properties. Use by permits, this is what you saw this evening. You have to find specifically that the use will not result in a substantial or undue adverse impact on the adjacent properties, that the characteristics of the site are suitable for the use, such as the size, shape, location, topography, and improvements, that the use of the location will be adequately served and not impose undue burden on the improvements or services to the city. And then in addition, you have to find that the use is in harmony with the general purpose, goals, objectives of the comprehensive plan, and that there's a proven community, or that there's a proven community need for the proposed use at that given location. So those are the criteria for use by permits. And at this point, I'll just pause. Use by permits are similar to conditional use permits in that they need an extra layer of scrutiny, but in Commerce City, we've determined that use by permits can be heard by the Board of Adjustment as opposed to a conditional use permit that has to go to the Planning Commission and City Council. And then the final type of application that the Board of Adjustment sees are administrative appeals. So those are appeals to administrative determinations. And you don't see very many of those, but applicants do have the ability to appeal your decision, or appeal the administrative decision to you all. Do you have any questions about land use before we move into quasi-judicial and ex parte and switch over to Elliot's portion of the presentation? Okay, great. I'll go ahead and advance the slides and let Elliot go through those then.
Yeah, good evening, Board. I just wanted to take this part of the presentation to go over the quasi-judicial role, your role in these hearings, and just some considerations and some practical guidance as you sit up there making your decisions. So in all applications that come before you, you are acting in a quasi-judicial capacity. And what that really means is that you are making decisions that impact specific property rights of property owners. So your decisions and your findings need to be based on the record that's presented before you. So staff reports, applicant testimony, public testimony, the kind of the four corners of the administrative record, which is the information presented to you at these hearings. So in these situations, we call it quasi-judicial because you're acting essentially in the role of a judge. You're providing due process and you're providing the role of the decision maker on specific property rights for property owners and others. So it's important that in these situations that you act like a judge, that you come into the hearings, and I say act like a judge before the hearing, during the hearing, and after the hearing. So it's important that you come in with an open mind, that you don't come in with a bias or a preconceived notion, a preconceived decision, that you make your decisions based on the evidence that's presented. It's important that board members don't engage in ex parte communications or pre-hearing advocacy prior to a case coming before you. And ex parte really means one-sided, legal Latin phrase, meaning one-sided, where it's one person communicating to you about a decision that you're making. And it's important you don't engage in those ex parte communications. I think there's a slide, well, I'll dig a little bit deeper on that, because it has the potential to invalidate your decision. So these rules are really here to protect, one, the property owner and the people whose rights you're making decisions on, and then just preserving your ability to make a decision from the dais. And on the next slide, as you come into and prepare for a hearing, what really goes a long way is the preparation you put in before the hearing. So really understanding Actually, I'll start with getting into the judge frame of mind early. So it's important to stay neutral. As I mentioned, it's important that the board in any quasi-judicial capacity is impartial, not coming in with preconceived notions and making decisions based on the evidence presented at the hearing. It's important that you avoid ex parte communications, and here's where the slide elaborates a little bit more. The real reason for that, as I mentioned, ex parte really means one-sided communication, with decisions being based on the record and you making decisions that impact property rights of individuals. It's important that that information be presented in the public space where others have the opportunity to comment on it, rebut the comments that are provided, or otherwise, provide testimony in opposition of the testimony that you hear. If you're engaging in ex parte communications, we don't have that open transparency when you're making decisions on people's property rights. And there are situations where engaging in ex parte decisions can invalidate your decision. So if there ever were an appeal, judges in a court proceeding could see those as creating a bias or impartiality, which could impact your decision. So it's a way to protect your decision. So if anyone ever were to approach you, whether it's a variance case or a height exception, whether it's the applicant, the community, or someone to talk to you about an application, could you just say, I really want to hear your opinion. I can't talk to you in this capacity. I encourage you to come to the public hearing and provide your testimony. And just a way to kind of turn it away so your ability to make decisions up here is preserved. Staying with kind of the pre-hearing preparation, it's important as you look at your staff report and as you prepare for our Tuesday meetings that you really understand the type of the decision that you're being asked to make. Is this a variance? Is this a height exception? Is this a use by permit? Because each of those application types, each of those hearings have different criteria which you're applying, kind of the facts of the case to the approval criteria. So that's kind of the baseline of what you need and the criteria where you're making your decision. And the staff report is an excellent tool for you to use for preparation and to get yourself in the frame of mind of what the approval criteria will be and what you need to do to prepare. The staff report, it's a great document that provides background and broad information about a particular case. It also provides the criteria for the particular land use matter that you will be deciding on. And the reports also have staff analysis on the various criteria that you can use kind of as a guidepost for your thinking of a case, questions you may want to ask. And as you look at the staff report, there are certainly times that you may not have all the information you need, and you may have questions. It's good to jot down questions before the hearing that you think you may need to make your decision on a particular land use case. And after the staff presentation and the applicant presentation, you're free to ask questions, elicit additional testimony and evidence that makes it into the record, which you could use to base your decision. And as you prepare on the next slide, the kind of just some guidelines for questions and things to think about as you prepare. Good questions are always tied to the criteria. So when you're looking at the variance, questions about the hardship or questions about how a particular application satisfies a criteria that you may have. I don't have, this is a slide from City Council presentation that deals with zone documents, but I think the council member Douglas, this is maybe the first one isn't. You had questions about the unique situation of a PUD document. That's one of the approval criteria. So where that comes from, it's one of the approval criteria in approving a zone document or a zone amendment. So if you have questions about how an application or amendment addresses a unique situation, you can certainly kind of prepare questions for the applicant and for the staff on how that particular application satisfies that requirement. And it's very good to get that onto the record, and we'll touch on this at the end, just to help for kind of selfishly on my point, if your decisions are ever appealed, it'll be my responsibility to defend your decision. So the more information, the more testimony that's on the record, the better it is and easier it is to justify your decision. And the questions that really start getting council and Board of Adjustment off of the course of what they're looking to do is really questions that aren't tied to the approval criteria. So if you start asking about, do you own or rent the home, or do you, things that aren't directly related to the approval, sometimes just muddies your thinking and muddies the waters on what you're really being asked to do.
Hey, Mr. Schaefer,
Yes.
will we get a copy of this?
Of course.
All right. I want to send this slide to some colleagues.
Certainly, yeah.
I really like this one. Sometimes we go wandering off. I'm like, no, come back. Don't get out of the weeds, please.
Yeah, no, this will be provided to you.
All right, cool. I want to send it to our attorney and be like, can we talk about this at our next training? This slide in particular. Thank you.
And then to wrap up the pre-hearing, as you're thinking about a particular case, it's important to know that this hearing is really the hearing that an applicant will have. So you are providing the applicant due process in making a decision based on our land use code, the land development code. So if your decision is ever appealed, it will be what's called on the record. So if someone disagrees, whether it's an applicant or someone else with standing, disagrees with your decision, they would appeal to the district court. Your decision would be based on the four corners of the administrative record, so the evidence and testimony that's provided, and then your motion and the decision that you actually make. Courts generally look at, the main things they look at when there's an administrative body making a decision are the procedures you used. Does it comply with your procedures, and was everyone aware of what was going on? The evidence you considered, and then the reasons for your decision. So that's why it's important to deliberate and talk about applications, especially controversial applications, to have deliberations on the dais, to understand your thinking, and really elaborate on why a certain criteria is or is not met. So that way, if there is an appeal, your rationale is clearly in the record, and as the attorneys write the brief on why the Board of Adjustments was correct in making their decision, we could point to the transcript and point to the record and say, this is why they thought this was or was not a hardship on a particular application, in a variance, for example. It's also important, as you're going through your pre-hearing prep, to know what's important to you. So know what you need to make your decision, and if it's not contained in the staff report, you can have a list of things that you want either the applicant to provide information on or staff to provide information on. And when it's your time to ask questions of staff, the applicant, and any public who testifies, you could certainly ask that to bring that information into the record. And the record is really key in these situations. So if there's ever anything additional information you want, ask those questions to really develop the record and bring out the basis for your decision, or bring out the information for the basis for your decision.
So if we do not have information that has been provided prior in the staff report, and we want more information, we can table the case, correct, until we get it?
You can continue cases, yes.
Okay, I just want to clear.
Yeah, no, I think exactly. One of the slides, I think, as you're making your decisions, you can approve with conditions, or deny is what is stated in the code for all of the land use applications, but you can always postpone and request additional information to be provided. So if you don't have sufficient information, I think the last case, our last hearing we had, there was potentially a situation where you needed additional information, certainly within your right to ask for a motion to postpone or postpone the hearing and request specific information to be brought back.
Well, yeah, there was a question. Thank you
Yep.
for going back to that. I was like, yes, there was something.
Is there a way if you had information that staff could provide to ask that question or ask to get that data prior to the meeting, so that, because these things, when you table things, it costs the applicant money. and
Yeah.
It's a lot, it can be inconvenience. Is there a way to get information that can be used if you frame the question during the hearing.
If there is information that you think you need, you could certainly reach out to myself and the staff. We don't want to engage in a back and forth on the specifics of a case, but if there's information that you need presented at a hearing to make your decision, you can request, say, I want to know, I can't think of one offhand for how many other.
Traffic counts or something like that.
Yeah, I think the kind of the PUDs and some of the zone documents will come to mind. But I think if there's something you need to help make your decision, you can ask staff to include that and present that in as part of their presentation. Or if there's information that, especially if it needs to be researched, say, I would really like this information at the hearing, and if you have a question, staff could do the research, and if it's not brought up in the hearing, as staff or by the applicant, you can ask for the research or the information that you are seeking.
But just to clarify, if one of us asks the question prior to the hearing, it will go to the applicant and the information will be sent to the applicant and all of us, correct? For transparency.
If you have, that's why if you have questions or if you have particular information that you need, you can request staff not to provide it to you outside of the record, but say, I would like to know X, or I will be asking questions on X. We don't want to engage in dialogue back and forth with the staff and the board, but if there's information you need to make a decision.
If you want to give us a heads up that you're going to ask about something that's really technical or complicated or is research that we would need to do, like say you wanted to know how many other variances were approved in that neighborhood for setbacks, we'd have to do a lot of research to figure that out. So you might give us a call before the meeting and say, I plan to ask you how many other variances have been approved in this neighborhood. And that would allow us time to do that research before the meeting. But we don't want to engage in dialogue with the whole group. We don't want to be sending communications out or emails that are pertaining to the facts of the case ahead of the hearing. You would just be more like giving us a heads up that you're going to ask about something so that we have time to research it.
Okay. The reason why I ask, and every attorney is a little different, I've had attorneys it'll go back out to everyone because it'll be a part of our packet for the public to have it at hand. So I was just curious about those little nuances.
Yeah, we wouldn't engage. So if you asked, we wouldn't provide the information directly to you. It would be provided as part of the hearing.
Okay,
So
cool.
so everyone is, yes.
That's what I was trying. I'm like,
Yes,
why
yeah,
is it
no.
just going to one? Like,
No,
that seems
yeah,
a little,
on a particular case, no, we would not provide you with a response to a specific question.
Okay.
It would be brought up in the public hearing, in the public forum, so it's part of the record, and there's not a dialogue, ex parte communications, and you potentially being influenced outside of the record.
All right, cool. I just wanted to clarify that.
Yeah, no, thank you. Yes, yeah.
Well, emails to the city attorney are protected,
Potentially.
yeah, but.
Yeah. Yeah, there are certain exceptions to CORA, but generally, almost anything in the public realm is a public document that would be subject to public inspection, as long as, and if it doesn't fit within a CORA exception, it would be a public record disclosed. And then moving to the next slide, excuse me, at the hearing, and this is always one of the difficult comments in these presentations. It's not your job to decide whether you like an application or if it presents a good idea. So your job is really to listen to the facts, the testimony, and the evidence at the hearing, and then apply those facts to a standardized set of review criteria and make a decision on whether that application meets them. So we're not here necessarily judging, is this a good variance, a bad variance? It's, do they meet the requirements of the variance? Was the testimony and evidence, did it satisfy these requirements? And if it does, that's when approval is the the path that the board should take, subject to, conditions that need to be imposed for whatever reason on a case. What's that?
Our feelings don't count.
Yes.
And that of the public though, so if we had something that is in line, everything checks all the boxes, everything's there, but there's a lot of public outcry, is that something we could consider, or would we still want to stick to, what would be that kind of outcome if we had a lot of public?
So you have to tie it back to the criteria. So for instance, the neighbors might be saying, this is gonna have an impact on me. I'm gonna have visual impacts of this proposed improvement. That would tie back to the criteria, as opposed, so that's where you would try to ask questions of the neighbors to see if you can make sure it's not just an issue of they don't like the applicant or there's bad relationships. I've advised Board of Adjustments in the past, it's not about who's getting along with one another. It's about what impact that variance is gonna have on the neighborhood. And not just the person that lives there today, but the future impacts to that neighborhood. Because sometimes you have someone that's supporting a variance just because it's their neighbor. And you have to think about, what if they sold that property in a year and then someone else is living there? Are there gonna be impacts to that property? And that's what your criteria are addressing.
And on the next slide, just continuing with the due process theme, at the hearing, it's, fundamental fairness is important. So it's important that you stay neutral, and on the dais, you don't make prejudicial comments, especially during the testimony phase. It's important that you listen to testimony because you will be making your decision, determining the facts of the case and making your decision based on the evidence that's provided. And the hearing is the time to ask questions. So prior to you get to the closing of the hearing and when you start deliberating, the practice with Commerce City has been to get your questions asked of the applicant and of staff prior to the closing of the hearing and the motion is made and deliberations are being done. So if there's information you need prior to the close of the hearing is when it should be done. It's also important not to offer your own testimony, your own evidence from the dais. You are the judge in these situations, so you shouldn't be the fact finder. You shouldn't be the one saying, I did my own research and know there's been 32 variances granted in a 2-mile radius. That should really, if that's tied to an approval criteria and information you need, that should really come out during the public testimony phase and as part of your questions to get information into the record so you can base your decision based on the evidence presented.
For the hearings, before we get to deliberations, for impartiality, like when you go to court, who goes first? Does the applicant or the prosecutor? Man, I think I'm saying this wrong, but because our planners are essentially advocating for the municipality, here's the case. And the applicant is saying, I want to. Who normally in court goes first? Because here, I can't remember.
Yeah, here.
Planner, I don't know. It's just very interesting how information is presented to us. And I find it very kind of interesting. So I wanted to clarify that.
Yeah, in a typical trial, it would be the plaintiff's obligation. They have the burden of proof, so they would present their case first. The prosecutor in a criminal case would present their evidence first, and then the defendant or defense provides their defense. That's the typical process in a court case. Quasi-judicial and land use cases are a little bit different. Just because it's not as quite of an adversarial situation. Staff and the other jurisdictions, I think jurisdictions handle it differently on who goes first and the order of presentation. With Commerce City, staff gives a general overview of kind of the review criteria, what was done by staff and how staff believes based on the development and review team and other review rounds that an application has gone through, staff's analysis of the presentation. And I think this is governed by the Board of Adjustments rules and procedures, and then the applicant has the opportunity to present their case. And I think they have a time frame or a time period in which they have to present their case. So that's the way we have it set up, and then public testimony after the applicant. I think it's important to remember that the burden of proof is always with the applicant. So it's their obligation to prove and to satisfy that the approval criteria have been met. And I think sometimes it gets to the level of sophistication of an applicant or who they have involved. Whenever attorneys are involved, I think they'll certainly craft a presentation and an argument based on the approval criteria. Sometimes when an applicant doesn't have an attorney or doesn't have representation that has experience in land use cases, it's not quite as cohesive, but the burden is always with the applicant to prove their case.
Thank you.
And on deliberations, I have a few slides on deliberations. So once you've heard the testimony and the evidence and we've closed the public hearing, this is the opportunity where you could start to take a stand and let your feelings known on a particular application, on how something does or does not meet the approval criteria. And this is also where discussion of the evidence is critical, especially if there's any potential for a legal challenge. The more you deliberate and the more you build the record and explain your rationale for a decision, especially if we're getting into the world of a denial and an applicant may challenge your decision, the more you build and discuss the reasons for your decision, the better it is for the applicant, for the city to justify and uphold your decision, or fight to uphold your decision. And it's a way we could look, we would use the transcript to point and explain why you made your decision. So if there is not those deliberations, and it's just a conclusion, yes, I approve, or yes, I deny, we're in a difficult position to uphold your decision. And on the next slide, we just have a few tips on deliberations. So focus on the key issues and the criteria. I think that's why it's really important, the preparation you do for the hearing, really understanding the criteria and knowing what you're being asked to do and understanding the facts of the case or the background of the case, that really goes a long way in being able to explain your rationale and deliberate as you sit there and you discuss a motion and how to act on an application. It's important that you discuss the evidence. So this is where we don't want you kind of pulling in information that wasn't presented during the hearing. So really focusing on what was presented, the key issues that were presented, and the criteria for a particular decision, and really drill it down on why. So if someone says, I don't think this meets criteria A, okay, why doesn't it meet criteria A? And really drill down on the why and have your why tied back to the evidence of the hearing. And like I said, it puts, selfishly, it puts me in a good position to uphold your decision and make sure that your decision is,
We want you protecting what we
exactly.
settled.
And the more you deliberate and the more you put into the record, the easier it is for the city attorney's office and the city to stand by your decision and have it upheld if it is challenged.
Can I ask, when we get to our deliberations during our regular presentations, can we have a slide of just here's the criteria so that it's on the board and the public can review it, and then also the recommended motion that staff is making? That way it makes it easier. I don't have to look for a paper, or I don't know, the app system that we use for our agendas is so clunky and I hate it. I'm sorry.
Yeah.
So it's very hard for me to figure this out, and then I'm supposed to have a deliberation. So if it was on a slide when we get to that phase, it'll make your job easier and then our job easier to actually have that conversation.
We can definitely put that criteria slide back up when you're deliberating. I don't want to put the motion up on the screen. That's something that we hand out to you so that you have that at the dais.
Okay. I just wanted to have that
Okay.
conversation, but at least the criteria makes us sound like, oh, this is why I'm doing
Yeah, no, certainly would help you. I know with city council, I think they have a binder that staff had put together where it has the various land use applications, and you could flip to the criteria. So we could look to do something similar. So, you just have a little 3-ring binder with the information, but we could also put it up on the, work with staff to make sure we get the information in front of you.
And then one thing for me personally, you mentioned past variances as a criteria. That's one thing I always find helpful looking at cases is if we've had any similar ones in the area that have been approved in kind of a general why. It was a topography issue. Was it the lot was too small and that's why it was? It helps with the deliberation. Just, I don't know. I know I'm going to pre-ask that, so.
Yeah, well, and the only thing I'll say, I've done Board of Adjustments for, 20-plus years. And one of the things that I always caution you on is that every variance stands on its own. And you have to make your findings related to that particular property. So just, if there's a trend, then that's something that should go to city council as, carports, for example. If you were seeing a ton of carport variances, you'd want to raise that with your council member, or the council member would bring that up and say, we need to change the code related to carports because we're seeing all these variances. So if it's something systemic, that relates to something we could address through a code change, rather than applying multiple variances, then we can do it that way. But I just caution you on relying too much on the history of variances in a neighborhood, because the circumstances of the variance change from property to property.
Oh, no, I totally agree with you. The reason why I find it helpful is to see, is there a trend going on? And maybe it's not noticeable because we haven't seen those odd things. When I was a planner, we had lakes in everyone, it was a cottage and you could allow small things. Well, we had annually 30 or 40 variances and they were all getting approved, but we just would not change the code, and I don't know why, but maybe it was a moneymaker. I don't know, it was only $500, but it was they're always getting approved, but no one really tracked it.
Yeah.
But it was the same case, and you just being the planner, putting up, I'm like, why do we keep doing this? And so it's just kind of an odd thing.
Yeah.
That's why. But
Something that the planners are doing before we get, because it seems like they're pretty, the cases are pretty cut and dried and vetted before we get them. So that's something that they look at before it comes here.
Variances, we don't have that many Board of Adjustment meetings throughout the year. So I don't think we're seeing great trends in different parts of the community for different types of variances right now. Other communities I've worked for, we had 4 or 5 variances a month, every month. And so just the volume of cases, for instance, we were looking at, everybody wanted to do entry walls. And so we said, okay, instead of doing variances for entry walls, let's change the code and just allow them across the board, but within certain parameters. So rather than the piecemeal approach of variance by variance to the fence code, we just said entry walls are something that the community wants, so let's come up with some regulations related to entry walls. So I think that's where those trends come into play, is when we identify those, we would go to council and say, we're seeing a lot of variances with this one thing. I just don't think we've seen that lately because we have so few variances here in Commerce City.
thank you.
Yes.
Is there a certain threshold that staff can approve on variance requests?
I was just gonna say that, that's part of the reason you don't see as many variances, is because we have the authority to approve up to 20% deviation. And so we can do that through a minor modification without it coming forward as a variance. So minor things staff can handle.
How's that 20% calculated?
It's 20% of the code standard.
Can you give an example?
So if it was a 10-foot setback, then we could do, what's 20% of 10 feet?
2 feet?
Yeah, 2 feet. We could do up to 2 feet.
Oh, okay.
I was trying to pick an easy one. Then I was thinking inches.
All right, thank you.
Yeah,
And that's just one variance. It's like if they had like 3, is it 20% for each one or 20% total?
you mean like if they were asking for like a setback and a height?
Yeah,
and-
they had 2 setbacks and a lot coverage issue.
Yeah, it would be on each, 20% on each.
Cool, thank you.
And then the last slide to wrap up my piece of the presentation is just tied to the deliberations is your decision. So I think, Board Member Fry, your comment, having a guiding document to help the decisions and deliberation. So the staff report is a great tool. The script, the ordinance itself, we don't make resolutions with the Board of Adjustments, but the documents that are provided to you, and we could certainly improve on, making sure that you have the criteria in front of you as you're evaluating and making your decision. And as I mentioned earlier, the board has the authority to approve with conditions, deny, and always the right to continue if there's not the information you need to make your decision or you don't feel comfortable voting based on the evidence. The one comment on conditions is just to be somewhat cautious as you're imposing them kind of from the dais. Conditions, it'll be staff's obligation to enforce the conditions that are imposed on an applicant. So it's important that
We
that
don't go
they're
crazy.
that they're clear, they're understandable, and that they're enforceable. And then also that it's tied to quasi judicial boards and decision makers in land use cases often run into issues when the conditions aren't tied to established legislation. So if you're imposing kind of arbitrary conditions that aren't tied to the approval criteria, aren't tied to a need to mitigate an impact of a decision, of an application, that's when potential issues are run into. And then just a quick comment on, so your decisions, they are the final decisions on these applications. So as I mentioned, this is the hearing that an applicant gets to determine their property rights. If anyone decides to appeal your decision, it's what's known as a Rule 106 appeal, which would be made to the district court, and the appeal would be on the record. So a transcript of the proceedings, the exhibits that are brought into, that you considered as part of the staff report, and the other exhibits that are presented, presentations, things like that. Courts will generally look to what the legal phrase is arbitrary and capricious. So they'll look to see if your decision was arbitrary and capricious, meaning not based on the evidence presented in the record or not related to the approval criteria, or if it was reasonable based on the evidence and the rationale for your decision. And I believe that is our last slide. And happy to answer any questions that the board may have.
I appreciated it a lot. Thank you. Makes it helpful to have these conversations, especially since we don't have so many meetings. It keeps us on our toes.
And it's helpful since the board kind of like shuffled, like had a lot of new people, I'm relatively new, that are folks who've been here longer, so it's really helpful to kind of keep us on the same page with how we're operating.
Yeah, certainly.
Well, thank you for taking the time tonight for the study session. We appreciate the opportunity to present to you.
Cool.
Is it possible to get a hard copy of this, or will it be only by email?
We could print that and leave that for you.
That'd
We
be awesome.
changed it up just a little bit, Councilmember Douglas, from the one that you saw.
Okay. All right, that'd be
Made
great.
it more specific to Board of Adjustment.
Thank you.
But we thought it was helpful for them to see the big picture too.
Oh, yeah, no, Great presentation. Thank you.
So if you have nothing else, you can adjourn your study session and be on with your evening. Thank you. Sure. Thank you. Thanks, Elliot.
Yeah, thank you. It's a good job.